Excellent. Tonight, our topic is striking and really workers' rights in Jewish law. And one might, when they hear about workers' rights, they might think about Karl Marx, who I just learned his father was a rabbi. Obviously, did not continue because I believe he was baptized, but he's still considered a Jew. And in fact, he's related through this, related to this great rabbi Katzenellenbogen, and my wife on her side of the family is also distantly related. So in a very, very distant way, I can trace my extended family back to Karl Marx. So how appropriate that we're talking about workers' rights. Hello, Leonard. But we're going to explore three questions tonight, and I'll still open it up to hear what people think about it. So the first question, and again, you may not have background for this, but this is more like ethically under your general understanding of Judaism. The three questions we'll explore are, should workers in general have rights? Can a worker just straight up and quit? Does a worker have, even if they're under contract, can they just say, you know what, I'm done. You have no right to as opposed to, a slave or a servant. I quit and you can't stop me. And then the third question that we'll explore is, are there any exceptions to that? Are there certain professions where it would be inappropriate or perhaps even forbidden to a worker to just up and walk away? So those three questions. Do you think workers have general rights in Jewish law, that Jewish law recognizes the idea that employees, workers have rights? Can a worker just quit, which is another way of saying strike? And are there certain professions that should be an exception? Meaning if the average, person, if a plumber can be like, I'm done, no more toilets for me. Are there certain professions where it should be against Jewish law and say, I'm sorry, you can't quit. We can talk, we can negotiate, but you have to keep working. So before we get into the sources, throw up your hands if you have any thoughts. What do you think Judaism, Jewish law might have to say about those three questions? Yeah, I'm unmuting you, Gloria and Leonard. Go for
I
it.
just have a question. You said if a worker just ups and quits, that's like um, being on strike.
So I mean, obviously it's not the exact same thing, because one who, and in fact, in my research, the rabbis did make a distinction, or some of the contemporary writers, between straight up quitting, which we will talk about, and striking, because striking is not I'm done with this job forever. Yeah, striking is not I'm done with this job forever. Striking is I refuse to work until you respect my rights to go back. We'll see that those questions become connected in Jewish law, but you're right that there is some level of distinction, because striking is a way of protesting. And we actually had a class on civil disobedience, and that Judaism does recognize the right to protest in the face of abuse, and evil, etc., like that. But as a basic thing, does a worker just have a right to say, I refuse to do my job and you can't make me? Not in that petulant, childish tone, but that's one of the basic questions. Do you think Judaism, and again, they're not just like in the, I don't hire a kid and say, I'll pay you $5 to shovel my front walkway. And they're like, it's too much. I'm sorry, I can't do it. What power do I have? We're talking about somebody who's contracted and is like, I know my contract is a year, there's another year on it, but I'm done and you can't stop me. You can't throw me in jail. Maybe there's other repercussions, but you cannot force me to work. Whereas with a slave, certainly one could force them. All right. Well, then we will jump into it. And as I said, there's really three questions. And Gloria and Leonard, I'll leave you unmuted. There are three questions. And the first one is about the general idea of workers' rights. Now, again, we're using, and again, when we say workers' rights, we often think about unions, which is appropriate. And we will explore that tonight, and I'll discuss it more later. But a lot of the language and the way we understand unions today didn't necessarily exist in rabbinic language, but not so far off. And you'll see in this very famous work related to this conversation, which is quoted by all the rabbis who talk about unionizing. And they bring up this particular Gemara, and the context, interestingly enough, they're talking about, I think before, was about charity workers and their roles in the city. So important workers in the city. So Gloria, if you would please take this first source from the Talmud Bavli, please.
Workers unite. Similarly, it is permitted for the residents of the city to set the measures used in that city, the prices set for products sold there, and the wages paid to its workers, and to fine people for violating their specifications in order to enforce observance of these halachot. This marks the end of the Baraita, and the details of which the Gemara proceed to analyze.
So before we go on, the language there is certainly evocative of, the workers shall control the means of production. Now, again, there's a broader context here in terms of certain mitzvot about paying workers, et cetera, like that. But the fundamental, it's quite explicit here, and we'll see it codified in the 16th century Shulchan Aruch, that workers have a right to demand that they be paid a certain amount and that a certain amount is charged for their products. And it's very much inclusive in general. It's not about one person talking to their employer. It really sounds like a union here. We believe that wheat prices should, a pound of wheat should go for this much money. Our employers who own the farms need to do these things, et cetera, like that. And more importantly, violations. That sounds very much like a union. When a workers' union, the people they're working for violate it, there are penalties and charges and fines. So this very much sounds like a union, but there is a fascinating limitation that comes up that we will see come out in the rest of this section. So please, Gloria. Rav Yemar bar Shalamya
raised an objection to Rava. Isn't it stated among actions that the residents of a city may take and to fine people for violating their specifications, that is, those ordinances that the residents passed? Rav did not respond to him. Rav Papa said he did well that he did not respond to him, as this matter applies only where there is no important person in the city, in which case it is permitted for the residents of the city to draw up ordinances on their own. But where there is an important person, it is not in the residents' power to make stipulations, that is, regulations. Rather, they are required to obtain the approval of the city's leading authority to give force to their regulations.
So this is fascinating. And the Hebrew that they use for this important person is just Adam Chashuv, literally an important person. And what does that mean? Now, the rabbis generally understand that this is either a rabbi or just someone who has a great authority and intellect. But essentially what this is saying is, if, again, let's say all of the wheat workers are unhappy with how much people are paying for their wheat or how they're being treated, if there is a leading light in the city, the rabbi of the town, which some towns and some countries even have today, they need to go check and say, may we unionize? If there is not one, then they can unionize. So the question is, how do we recognize that great person, et cetera? So we'll come back to that in a moment. But the takeaway is this: assuming there's no great authority in the city that you have to get permission, and by the way, they could give you permission to unionize. Barring that issue, the idea of workers' rights and workers being able to stand up and demand a certain amount of pay, which really this is what striking is really all about. This is separate from being able to walk off the job, but it's the basic idea behind it. We can demand better pay, better benefits, and if you don't give it to us and we agree upon it, the majority agree upon it, then we can penalize whoever the you is. So this is a very, very powerful foundational source. And in fact, Leonard, as you will see here in the 16th century Shulchan Aruch, it is codified into law. So please, Leonard.
The individuals in a profession are permitted to implement regulations on their profession, such as by agreeing amongst them that one may not work on a day that other is working, or anything similar, and that anyone who violates the condition will receive such and such punishment.
And just pause there for a moment. There's a question that a lot of people ask about. Let's say I work for a company. Let's say I work for Google or actually Amazon in Alabama, where I don't know how the vote went, but I know they were voting on unionizing, and they're all doing it. And I say, but I don't want to unionize. Do I have to strike with you guys? Do I have to do everything you're doing? And it's saying here that yes, If the majority is accepting certain things upon themselves, then everybody has to go along with whatever that unionizing type work is. So there's a lot here that's being not only permitted, but covered that applies to modern day situations. Please, Leonard.
This, that people of a trade may create regulations, is where all of them do it together. If only 2 or 3 of them create them, however, it would not be effective.
So if a company of 100 people and 2 decide to create a union and the rest disagree, that's not a union. Go ahead.
When is this true? In a jurisdiction that does not have a prestigious scholar appointed to oversee the public. If they do have such an official, however, their condition or the condition of the people of the city would be of no effect, and they would not have the power to punish or cause a loss to anyone who does not fulfill the condition unless they created the regulation with the knowledge of the official. If there is no loss to anyone, however, they may create whatever regulations they want amongst themselves.
Excellent. Thank you, Leonard. So Ken, welcome. And just to review, this is only our second source, but there's basically 3 questions tonight. One is general workers' rights. Does Jewish law recognize that? One is the right for Jews to just quit, which is not the same thing as striking, but it gets very similar. And the third one is assuming that workers can demand better pay and they are allowed to strike. Does that apply to every profession? Are there exceptions? And what we saw here, based on an explicit Gemara, a very clear one, is that workers have the right in a city to demand better pay, to demand how much their products will be sold for. So very much like a union, the only exception to that is if there's some kind of great authority in the city, they need to get permission from said person. However, if there isn't that person in a city, like in Milwaukee, we have some great rabbis, but I don't think there's a one leading rabbi for the whole city. So if Jewish workers at some organization wanted to unionize based on this and demand pay, I don't think there's anyone they would have to go to get permission, at least the way this is being presented. One thing they do mention here at the end is talking about a loss. Meaning that if we decide to unionize or quit or strike, whatever, and nobody's going to lose out by it, us taking off a week, maybe people won't get their wheat for a week, but it's not the end of the world, then there's no problems. However, if us unionizing or striking for a week might have some significant negative effect on the community or others, things might be a little iffy. We will come back to that in the end. But just on this idea essentially of unionizing and demanding, so we're not on striking yet, but on demanding better pay, demanding better things for the employees, benefits, we see that it is quite permitted, with one exception, if there's someone in town who's a great authority, and the question is, does that authority exist? And in fact, I didn't bring the source here because I didn't want to have 10 pages, but Rav Moshe Feinstein Zatzal was explicitly asked about unionizing and striking. And what he said is, today, we really don't have those singular authorities in cities. Obviously, there could be exceptions if there's a chief rabbi, but generally we don't have that. There's not that important person like like olden days in Chicago, you had like the boss who ran the city. So if that was a Jewish person, maybe that'd be the equivalent. We don't really have that today. Communities are really splintered into individual groups and shuls, etc. So Jewish workers would not, there's no single person they have to go to. So if a Jew wants to unionize, or Jews, in almost every case today, it would be permitted in Jewish law, barring the exceptions we'll hit in the end. So any questions on section A? And Ken, I know you just walked in, but I think that you know everything we know now. Beautiful. In fact, Ken, I'll leave you unmuted and I'll let you take over at the next section. So okay. The next question is there's kind of 2 components to it, because it's the idea of, with striking, the idea is not that I want to lose my job, not that I want to quit my job. The idea is I refuse to do my job, which I know will put pressure and put the heat on my owners because they need me to do the work. They need me. And hopefully they'll realize that it's better for them to compromise and give up something to get me back to work. That's striking. Quitting is I'm done with the job. Now, sometimes quitting can be a threat and can be a negotiation tool, but again, these 2 questions become connected. Striking even if it's temporary, would not be permitted at all if I at least didn't have the right to just quit. So the first thing we'll ask is, can a Jew just up and quit and say, I'm not doing my job anymore, I'm walking away? And then again, that's connected to the idea of temporarily striking as a form of protest. So kind of actually going to give you the first and second source, but the first source is what the whole conversation about, can I just quit? Whether I'm contracted, whether I have a year left on my contract, no matter what, people rely on me. I walk into school one day, I have a class to teach, and I'm like, I'm done. I refuse to work. Can someone force me to work? So the conversation always starts with, can this verse first source in section B from Vayikra, please?
Okay. For they are my servants, whom I freed from the land of Egypt. They may not give themselves over into servitude.
So that's the end of the verse, and then very quickly we will see how it is applied. So we go actually right to the Shulchan Aruch, and we see how it is applied to the question of a worker, and it starts a worker's in the middle of a job. So go ahead, Ken.
Okay. If the worker began working and retracted halfway through the day, he may retract, even if he already accepted payment for the work and cannot pay back the employee. He may retract, and the money owed will be a debt, because the verse states, for the Jews are servants to me and not servants to servants. For this reason, a worker is prohibited from hiring himself out to be in the employer's house for 3 years, even as a school teacher or a scribe.
Excellent. So the first part of that is the most important, which is, and by the way, this word retract here, the Hebrew there is choser, which means to return, but essentially means quit or to go back on our agreement. Now, one thing that we'll talk about in a moment is they're talking here about an hourly worker. So somebody pays me and say, I'll pay you $50. Can you show up on Tuesday, paint my house? They give me the $50 because they're like, oh, I trust you to finish. I start the job and I'm like, no, I'm done. I don't want to do it anymore. Now, I've done part of the job, so I've done some of the work. So there's a few factors here that are a little bit outside of our conversation. I've done $25 of work. They should let me have $25, but I need to pay back the other $25. Now, there's another thing. What if, because I quit in the middle, there's no one else to do it and it's going to cost them another $100? That's a whole conversation. If it's going to cost them more to hire someone else, I've caused them a loss. So I might need to pay them back. However, the most important thing here is this. The only being in the universe who owns me, who I could never quit or walk away from, is God. I am a servant to God, but I serve no man. And that's very important. If an Israelite had gone up to Pharaoh and be like, I'm done building your storage cities of Pitom and Ramses, I'm going to go now. Pharaoh would be like, oh, lovely, turn around so I can kill you. You can't walk away from Pharaoh because you were a slave to him. Human beings are now, obviously, even in Jewish law, and in fact, Thursday's class we're going to explore that in this week's Parsha of Mishpatim about slavery or indentured servitude, whatever it is, the limitations to that. But in terms of a regular job, the rabbis say, based on the verse that we only serve God, that no employer owns me and I can quit at any time. The only thing is I might owe him back the money and I can pay it off at some point, but he cannot own me. And again, you ask about, but there's slavery in the Torah, that adds a kink in it. But for our conversation in a regular job where servitude is not a factor, which it really isn't today anyways, this is 16th century, nobody can force me to work. They can take me to court over lost wages, lost payment, et cetera, like that, but no one can force me to work. And the understanding, or the way that it's taken then, is even with striking, then it would probably be permitted too. Now, there's no one explicitly, not no one, but that's not as explicit a source, but it's understood that this would be applied to striking as well. You can't force me to work. If I don't want to come into work, that's my choice. Now, I guess you could fire me. I can't stop you from doing that. But if I want to stop working and negotiate, that's my right. That is really important here. It is a right to be able to walk off the job at any point. And the only thing I need to square up is that I might owe you some money for it, business thing. So before we go on to the next source, any questions on that? The last two sources, really. Excellent. One question here, just to be explicit, because it talks here about somebody who, you hire to shovel your front porch that's covered in snow. But what about a hired worker? What about, an employee at a company who has a 3-year contract? So there's actually a debate amongst the rabbis whether or not a hired worker has this right, or sorry, whether a contracted worker has this right. And in the 17th century, there is a commentary on the Shulchan Aruch, specifically here on Choshen Mishpat, the laws of civil laws, and it is considered authoritative. And the Shach, Shabtai Kohen, was very, very young when he wrote this, but he takes up that debate. So Tamar, I'm going to go ahead and unmute you. And the Shach is very clear about whether or not we treat contracted workers any differently than hourly workers. Please, Tamar.
The Beit Yosef quotes the Ritva in the name of his teacher, who claims that permission to quit on the spot is only given to a hired hourly worker, but all who work contractually are not able to quit. In my humble opinion.
And now this is the Shach who is speaking here when he says, my humble opinion.
It appears that the rest of the halachic deciders are in agreement about this and don't hold this way. It appears to me that the fundamental principle here is that all Israel are servants to God and not servants to other men. And in all cases, one can retract.
So it doesn't matter whether I have a contract, whether I just agreed with a handshake to do a job, it doesn't matter. I have the right to quit at any time. So now we have established that workers can walk off the job at any time. And the worst case scenario is that their owners can say, look, you quit the job in the middle of the day and I lost $1,000. So we're going to work out a payment plan, but I can't force you to come back to work. And that workers can both unionize in terms of asking for better payment and stuff like that. And they can penalize their owners or their employers for not abiding by what they agree on. So both unionizing, the right to quit. So workers actually have quite a few rights in Jewish law. And again, the most powerful one is that no one can force me to work. The only one who can force me to work is God. And even God ultimately gives us free choice. There are consequences, and there's consequences to quitting a job in the middle of the day. Those are financial, but in terms of my personal status as a human being, I belong to no one but God. So I can walk away, and I can, not only can I demand that you pay me better, but I can expect that others who are working with me, as long as the majority want it, they can be forced to. And that's also a question that came before Rav Moshe Feinstein, Zatzal, is if most people are unionizing, can they force others to basically not cross the picket line? And he says that if it is a majority of people, then yeah, they can demand that their fellows not be scabs and go to work. So based on the sources we have just seen, Rav Moshe Feinstein and others, and there's some certainly disagree, but it's pretty accepted ruling that the idea of striking and unions is accepted very much so in Jewish law. It is respected and accepted is something legitimate. And it seems from the Gemara that the very idea of workers' rights is a pretty old school idea. It's definitely there. So before we go into the final section, are there any thoughts, comments, or questions up until now? You can just throw up your hand or an umbrella, anything to get my attention. Beautiful. So this last section here, there's two parts. The first one I brought an explicit source, and the other one I'll mention outside because it would require multiple sources and debates to represent it. But Rita, I'll go ahead and unmute you. And the background, or this section, is essentially, are there exceptions to this? And this is more about striking than unionizing, meaning most would probably accept that any profession can demand more benefits and better pay and dental, et cetera, like that. There's nothing wrong with asking that and even potentially penalizing the employers. But does everyone have the right to walk off the job and set up a picket line? And in the 80s in Israel, this question became very real because there was a doctor strike. And there were actually multiple letters you can find online in translation. And this is just one of them. And this was a section from a letter from two of the greatest rabbis of recent generations, Rabbi Yitzchak Yaakov Weiss and Rabbi Shlomo Zalman Auerbach, who passed away just a few years ago. And they co-wrote So that gives it a lot more weight. A letter to the hospital and to the doctors who were striking at the time. And it was, again, all the doctors. I don't know if it was just Shaare Zedek, which is a major hospital, or many hospitals. But Rita, this is what they had to say to the hospital and the doctors. Please.
We have heard that there are doctors who have abandoned their work in the hospital and have forsaken their patients. The situation is such that the number of physicians available in the hospital is even less than usually present on the Holy Shabbat. Assuming that the latter is the minimum needed for the saving of life, which is permissible on the Shabbat, the halacha is clearly spelled out in the Shulchan Aruch. A physician who withholds himself from healing is guilty of shedding blood. Wherefore, the obligation is upon you to assure the presence of an adequate medical staff in the hospital no less than on a regular Shabbat. All the physicians are obligated to fulfill the aforementioned. We ask that this is a ruling of ours be transmitted to all the physicians in the hospital.
Excellent, thank you. Now there are a few important distinctions that they make here, and one of the source that they bring in from the Shulchan Aruch is also important because there are people who won't go get medicine, and they're opposed to medicine and doctors because they say God will heal us. And the Shulchan Aruch is quite clear that doctors, not only is medicine permitted, but doctors must practice medicine. If they don't, they're allowing people to die. But based on that source, the issue here is really life and death. So what's between the lines here is that they're not saying that every doctor is forbidden to strike. What they're saying is that there needs to be some sort of agreement that there's enough doctors still working that it's not increasing life and death situations. So, the ER doctor, there always needed certain numbers on ER and a few doctors just in case there's an emergency. But we don't necessarily need every podiatrist to come into work. And there could be a podiatrist situation of life and death, but you have to have some doctors. So for all doctors to strike is forbidden by Jewish law because it'll cause people to die. That's why doctors are an exception. And again, it doesn't mean every doctor has to come into work. Some can strike, which will put a strain on the system. Regular checkups, other, voluntary procedures, regular procedures are put on hold. So it really presses the system, but you cannot have all doctors strike, which is what was happening. And then apparently it devolved into the doctors going on a hunger strike, which other rabbis found was forbidden because it made them weaker and they weren't able to do their jobs as well, which again would lead to loss of life. So it's pretty well accepted that doctors, at least all doctors, are not allowed to strike all at once. So it's not a clear exception that doctors can never strike, but it is not permitted for all doctors to go on strike like other professions. So a construction crew who's building an important building has every right to just say, we're stopping until you pay us a fair wage. But doctors, while they have a right to unionize and demand better pay, they have to work out a system whereby there will be enough doctors to prevent loss of life. So before we go on to the final thing that I'll just say outside, any questions on this source? And again, there are multiple letters from the head of hospitals, and they're all coming back to the same basic ideas that we recognize the right to strike, but not when it's going to lead to a loss of human life. Excellent. So the final source, or the final question here, one other potential exception, and there's a debate on it, so I didn't want to bring 5 more sources here, is about teachers. And the reason teachers are very interesting is first there's a distinction between Torah teachers and secular teachers. And the reason is that in Jewish law, the default is that Torah teachers, it's not a paid profession. No one should charge to teach Torah. The only reason that it's okay to pay Torah teachers and rabbis, etc., is because they don't have time to get another job and make a living. So this is paying them the wages that they would have gotten if they had time to get another job. But fundamentally, there's an issue with teachers demanding higher pay and striking because they're not regular employees, and it's not a privilege, it's a right to have Torah taught to us. So the debate is, can Torah teachers strike? Because essentially it's not about them getting paid more money, it's about them withholding Torah from Israel. And that's where the debate lies. So just like doctors protect our physical bodies, Jewish law struggles with Torah teachers who protect our spiritual bodies. And that's a real debate in the law. Now, there's different opinions. There's some who say, no, Torah teachers have just as much a right to strike as everyone else, and others who say, no, Torah is different. And again, secular teachers could strike. Not that secular studies are not important. I think they're just as valuable, and they all go together, but Jewish law would be much more open to recognize secular teachers striking. And, it's okay to go a few days without math, but not Torah teachers. And I believe Rav Moshe, again, rules on this, and then Ken, I'll unmute you, that Rav Moshe rules that ultimately teachers of Torah and Jewish studies could go on strike, but the threshold for when they can, meaning they can unionize, they can ask for legitimate benefits. They can't ask to be rich or anything because it's Torah. You're not supposed to get rich off Torah, but they can ask for a living wage, basic benefits. But for them to strike, the threshold needs to be high. It needs to be a bad situation before Torah teachers can strike. And there are others who say they can never strike. So yes, Ken, I'm unmuting you. And you had a question or point.
Yeah,
So, go ahead, please.
I was very sensitive when he said something about mathematicians, but we'll pass on that.
I said I disagree. I think secular teachers are just as important, but definitely within the context of this debate, there's a distinction between secular studies. And the reason for that is not necessarily about the value of math. It's more about the recognition that one is permitted to charge to teach math or history, et cetera, whereas Torah is something that fundamentally one can't pay for. And again, those of you who are members of Lake Park Synagogue, you're not paying me so that I'll teach you Torah. I will teach you Torah for free till the day I die. However, I could not be the rabbi of a synagogue if I wasn't receiving a living wage. So that's the option. Either a community has a rabbi who can help lead them, teach them Torah, but they have to, sustain that person so they can do that full time, or that person has to go elsewhere and they just don't have a rabbi. It's a very interesting way of rationalizing it, as it were.
Yeah, I guess the question I have, this is all well and good. And, basically, I grew up and am a union man, and probably I lost my job at the UWM because I organized or revitalized the teachers union back in 67 or 8. So I'm sensitive to that, but I'm also sensitive to, to the other side of the question. This implies that, except for perhaps doctors, people could sort of walk off the job. And so is there another class where what is the obligation when I signed on to paint that house and I leave halfway through? What is my moral obligation? And what did the rabbis say then in terms of that honoring that contract?
So that goes back to the conversation that Shabtai HaKohen, the Shach, talks about, this debate going back to the Ritva, Rabbi Yom Tov Shvili, I want to say 12th century. I could be totally wrong on that, but he says that a contract is different. It creates a different kind of relationship. But again, the Shach disagrees and becomes the codified law, which is ultimately, no matter what the contract is, ethically, no one owns me and I can walk off the job at any point. Now, this is assuming that I'm not walking off the job because I'm bored and I want to go home and watch, the Super Bowl. I'm walking off the job because I've asked for something legitimate and I couldn't get it through compromise or another means. And this is the only tool I have left me. And this goes back to the Gemara we started with, which is a recognition that workers have the right to ask for legitimate pay and to control the means of production, et cetera. And again, there was an interesting thing. If there's a clear leader of the city, one has to go through them. And, there's a long conversation. Why do we need that? It might just be to prevent chaos or recognize, giving a rabbi the status of a judge, going back to the days of the prophets, et cetera, kings. But ultimately, we don't really have that today. So workers have every right to protect themselves. So it's actually, if somebody walks off the job for no reason, that's immoral. If somebody walks off the job to protect themselves and it's the only tool they have to have a voice, then Jewish law seems, more than seems, Rav Moshe is quite explicit, Jewish law totally recognizes that and validates that. And if it's a profession where it's a matter of life and death, or certainly Torah, which is the lifeblood of the Jewish people, the threshold might be higher, but that doesn't mean it can never happen. And even with the doctors, certain doctors can walk off the, can walk off the job and make life difficult for the hospitals because their rights and their livelihood matters. They are not slaves. And that's really what this comes down to. The reason not just unions, but striking are okay is because people are not slaves. They are free to put their rights first. A slave has to put the rights of their master first. A free person puts their rights first. Now, again, as in the religious context here, we put God first before our job. But other than that relationship, we are allowed and permitted to put ourselves first as long as what we're asking is appropriate and reasonable. If I say I'm going to quit unless you buy me a Lamborghini, that I don't know if any rabbinic court would uphold that. But if I'm going to say I can't afford to pay my rent, or I can't pay my kids through school, or like I can barely afford my life, then a rabbinic court would say that's an appropriate reason to strike and walk off the job. So the kind of unionizing that you did, I think, would be recognized by Jewish law and upheld very much. And obviously, in the real world, there's repercussions to unionizing. It costs more money, everything like that. But ultimately, what's put first here, I think, on all the sources is the human component. Look, a company may say, look, we can't, if you unionize, we can't afford to stay open. That's devastating. And everyone losing their job is really horrible. But I think the factor here is that people come first. People are more important, the employees are more important than the employer. And I think that's an important takeaway from all this. And yes, compromise is very, very important. You have to be real and practical about it and consider the repercussions. But the employer has every right to protect themselves, their family, and their livelihood. Excellent. Any other questions? You throw up your hand and mute. Excellent.